Welcome back. A high-profile jury trial comes to its close this week with Waukesha Parade Tragedy suspect Darrell Brooks convicted of 6 counts of first-degree intentional homicide, as well as dozens of other charges. He killed 6 and hit more than 60 more when mowing his red SUV through the city's Christmas parade last year. He represented himself throughout his trial, displaying continually disruptive, odd, and belligerent behavior throughout. I spoke with criminal defense attorney Chris Van Wagner earlier this week. I want to talk first about some of the things he said at the end of the trial closing statements. One thing he brought up a lot, the judge wouldn't let him talk about jury nullification to the jury. He wanted to. What is that?
Well, jury nullification is really a simple concept when you boil it down and take all the legal terms out. It's saying it doesn't matter whether I did this or not, you should let me go. Now, when would that make sense? I'll give an easy example. A lot of people think marijuana is legal. It's not. If somebody's charged with possession of marijuana and they want to go to trial, the lawyer can try to communicate to the jury the sense that this is really not something they should convict him of. And there's some support in law in general, because the jury instruction says if the jury's convinced beyond a reasonable doubt that he is guilty, they should convict. If they have a reasonable doubt, they must acquit. So should versus must makes it a little soft. But what you can't do is argue directly to a jury that they can ignore the law and acquit them for some reason unrelated to the law and the facts.
So what I'm hearing, marijuana possession is a much different, much smaller. Trying to argue that it should be used in a first-degree intentional homicide case is absurd?
Well, it's not even that's an understatement. Absurd? No. What it is it's insanity, because there's nothing to say to a jury that people who have died because of these actions he engaged in somehow don't matter. That's essentially what he wanted to argue. Look, that's a fool's errand.
We know that he plans to appeal this case. We know that. He said so. It's very likely he's going to try to appeal it. What could possibly help him in appeal? He mentioned in his closing statements, oh, there was evidence that wasn't presented. Some people have said, oh, there's no way he could get a fair trial in Waukesha. What's going to help him if he can put together an appeal with any basis?
You know, that's a good question, and a lot of people have asked me, just in my family and friends, is he trying to get a new trial by acting the way he is? And I don't have insight into what he's thinking. I know he has been diagnosed with mental health concerns, with mental illnesses. He is not somebody who was found to be incompetent. In other words, he understands the court proceeding. But when it comes to, say, the evidence he said that was excluded, that didn't come in front of the jury, if a lawyer is appointed to review his case, and I am certain they will be, even though he didn't want one at trial, they have to read the transcripts, they have to look at everything to do with the case. They will also have an investigator look into anything that could have been used and was not. If they can find a piece of evidence that could have been used and would have made a difference in the case, they can ask Judge Darrell in a motion after sentencing, but before the appeals court, to order a new trial on the basis of not newly discovered evidence, but on the basis of the interest of justice, because critical evidence was kept out. Here's the fallacy in this case. The entire sequence of events is on video at one point or another. So the only evidence that really matters to the jury is A, what happened along the parade route, and B, what was in his mind. What was he thinking? Because intentional first-degree homicide means you formed the intent to kill. So the answer to the question about evidence he said should have come in and didn't, it's unlikely, but if they find it, they can present it to the same judge who presided, and she will weigh it and decide. I don't think there is any. You asked about other potential areas of appeal, and some people have asked me, and you implied this too, was his behavior an effort to say, I'm trying to screw up this case? Well, probably implicitly, yes, but really, he has a personality disorder where he didn't want to trust the people appointed to represent him. He wanted to do it himself, and as a result, there are things that didn't get done that, had I been a lawyer or somebody like me been a lawyer, would have been done. One would have been jury instructions that we would have wanted for lesser included offenses, and in this case, if she gave them, we're good, but nobody argued that. And so if a lawyer could have said, ladies and gentlemen, we've all heard the term blind rage. When somebody is in a domestic dispute at the level he was, because it's clear he was, and they're so angry that they just drive off wildly into the sunset and they run people down, it's rare that they have said, I intend to kill somebody. That is a key issue in this case, and it was never really presented to the jury.
But intent has been established as it can take place in a second's worth of time.
It can, but a defense lawyer who's arguing without emotion and without a personal interest in the case could also point out to the jury that we all do things at times without really intending them when we are angry. And that's what second degree is. So that could have been a defense.
Let's wrap up by talking about Judge Darrell for a second.
Yeah,
you
sure.
mentioned, like, I mean, she was, the patience that she displayed throughout the trial was remarkable. Is there any, some of that had to have been to avoid a mistrial, right? What missteps could she have done that would either cause a mistrial or bolster an appeal?
You know, that's a good question, and there's an easy answer, and then there's a harder answer. The easy answer is this. Many judges would not have exhibited their patience and would have cut him off and upbraided him in front of the jury on a regular basis, or may have just bound him and gagged him right there in the courtroom, which is legal, although I think that will change with the advent of Zoom. Either way, if she had exhibited anger to him on a regular basis, you have to remember that when a jury's sitting in a courtroom, they tend to trust the prosecutor. They distrust me and my client, defense. They clearly would distrust a defendant representing himself. And the person they most trust and they most rely on for opportunities to understand where they should go is the judge. And so the judge's most critical role is to always appear neutral and unbiased. If she had gone off the handle on him, the jury, if they see a judge routinely denigrating, insulting, or chastising a defendant in front of the jury and exhibiting anger toward the juror, they take their cue from the judge, and then the jury could be tainted. So that's what makes her performance important. When I say performance, that's what makes her work as a judge, her conduct, really important to preserving the record and making sure there is no appeal. She always removed the jury before she raised the temperature a little bit. So I think the entire state of Wisconsin, and certainly the people of Waukesha, owe her a debt of gratitude, because most judges in Waukesha would have just said, I want nothing to do with it. I live here, I work here, and it would have gone to a judge who might have had less patience.
Let's wrap it up on that note.
Sure.
I know the state of Wisconsin is breathing a sigh of relief as this trial comes to a close. Thank you, as always, for coming on to talk about it.
Thanks for having me. Have me back sometime.
I'll do my best.
Okay.
We will be right back.